You spent 40 years building it. The house, the retirement account, the savings your spouse doesn't have to touch for 20 years if something happens to you. You did everything right. You paid off the mortgage. You maxed the 401k. You even set up a beneficiary designation so the money would skip probate and go straight to your kids. And then one morning, a ruling comes down from the highest court in the land, and without a single phone call, without a single warning from your financial advisor, the legal shield you thought was protecting your assets quietly develops a crack. Not a crack anyone tells you about, not one you can see, but one that, depending on your state, your account type, and your specific situation, could cost you or your family tens of thousands of dollars. This is not a hypothetical. This is happening right now. And if you are between 55 and 80, if you have a paid off home, a traditional IRA, a pension, or a surviving spouse who depends on your planning, you need to understand what has changed, why it matters, and what you must do before it catches up with you. Here is the trap. For decades, retirees were told that certain assets were protected, IRAs shielded by federal law, homes protected by homestead exemptions, annuities wrapped in state-level creditor shields. The message from financial planners was consistent. Structure it right, and the government cannot touch it. Your creditors cannot touch it. Medicaid cannot claw it back. But the Supreme Court does not leave the rulebook unchanged forever, and certain rulings, particularly around inherited IRAs, Medicaid estate recovery, and the treatment of protected retirement assets in bankruptcy and creditor proceedings, have quietly redrawn the lines. What most seniors do not realize is this: the protection they were promised was conditional, and the conditions have changed. The dangerous part? Most people will not find out until they are already in a nursing home, already widowed, or already dead, leaving behind a family that will spend years fighting over what was supposed to be a guaranteed inheritance. Let's start with why this happens, because the system here is not accidental. It is architectural. When Congress created the IRA in 1974, the protection built into it was designed for the account owner, for you, the person who earned the income, paid the taxes in part, and was building toward their own retirement. The law was clear and firm. Your IRA is yours. In most states, creditors cannot touch it. Medicaid has limited reach into it during your lifetime. But then something changed. People started dying and leaving those IRAs to their children. Inherited IRAs became one of the most common wealth transfer tools in America. And for years, families assumed the protection traveled with the account. If dad's IRA was protected, then the IRA my son inherits from dad must be protected too. The Supreme Court said no. In a landmark ruling, the court held that inherited IRAs are not retirement funds. They are ordinary assets. They do not carry the same federal protections as the original account. And that single legal distinction, original versus inherited, opened the door to creditor claims, bankruptcy seizures, and estate complications that most families had never been told about. That was the first crack in the wall. Trap number one: the inherited IRA is not protected the way you think. When you leave your IRA to your adult child, that account does not get the legal armor it had when it was yours. If your child is going through a divorce when they inherit it, that money can be considered a marital asset. If your child files for bankruptcy, an inherited IRA can be liquidated to pay creditors. If your child has a lawsuit judgment against them, that account may be exposed. You spent a lifetime building it. You assumed you were leaving them something safe. But the moment it transfers to an inherited IRA in their name, the protection clock starts over. And in many states, it barely starts at all. The fix is not complicated, but it requires a conversation with an estate planning attorney before you die, not after. Properly structured trusts, specifically what is called a see-through trust or a conduit trust, can extend certain protections to your beneficiaries, but only if you set them up in advance. There is no retroactive option. Trap number two: Medicaid estate recovery is now reaching further than most retirees expect. Here is the scenario no one prepares for. A couple, married 42 years. One spouse goes into a nursing home. The other spouse, the community spouse, stays in the house. Medicaid pays for the nursing home care because their income and assets fall within the qualifying range. Seems like the system worked. Then the nursing home spouse dies. Then a year later, the community spouse dies too. And then the state shows up. Because Medicaid estate recovery rules allow the government to seek repayment of every dollar it spent on long term care from the estate of the deceased recipient. And in many states, that recovery can reach assets that pass through probate, including in some states, the family home. The Supreme Court has not stopped this, and some recent decisions have given states broader authority to define what counts as the estate. In states that use an expanded definition, assets with certain beneficiary designations, joint ownership structures, or life estate arrangements can now be captured in recovery proceedings. The house you lived in for 40 years, the one you assumed your daughter would inherit, could be subject to a Medicaid lien the moment you pass. Trap number 3. The rules around bankruptcy and protected assets have shifted state by state, and federal guidance has not kept up. This one hits people who are not even in a nursing home. Retirees living independently, drawing from IRAs and pensions, can find themselves exposed if they face unexpected liabilities, a lawsuit, a car accident, a business obligation from decades ago that resurfaces. Before the Clark versus Romecker decision, many retirees assumed federal law was a blanket. After it, attorneys across the country had to sit down with clients and explain that the blanket only covers the original account owner. Rollover IRAs have some protection. Inherited IRAs have almost none at the federal level. State laws vary wildly. Some states have passed their own protections for inherited IRAs. Many have not. If you do not know which category your state falls into, you are exposed and do not know it. Now let's make this concrete. Let's talk about the math. 2 sisters, same age, same situation. Both of them inherit a $300,000 traditional IRA from their father, who passed at 76. Sister 1 doesn't do anything differently. The IRA transfers as an inherited IRA in her name. A year later, her husband files for bankruptcy due to a failed business. The bankruptcy court determines that the inherited IRA is not protected under federal exemption law. The trustee liquidates the account to satisfy creditors. She loses $300,000. Her father's life savings, gone. Sister 2's father had worked with an estate planning attorney 2 years before he died. Instead of leaving the IRA directly to her, he set up a properly structured conduit trust as the beneficiary. When the father passed, the IRA funded the trust. The trust is a separate legal entity with specific spendthrift provisions. When the bankruptcy proceeding begins, the attorney successfully argues that the trust assets are protected from the husband's creditors. The money stays intact, same father, same amount, same daughter. 2 outcomes. The difference was a legal document that cost a few $1,000s and took 3 months to set up. The result was $300,000 preserved or lost. Do that math for your own family. So what do you do now? Move fast. Because this is not a problem you can fix retroactively. First, review every beneficiary designation you have on file, every IRA, every 401k, every annuity and life insurance policy. If any of them name a person directly, a child, a grandchild, sit down with an estate planning attorney and ask whether a trust as beneficiary would offer better protection given that person's financial situation. Second, if you or your spouse are over 65 and own a home, ask an elder law attorney about your state's Medicaid estate recovery rules. Ask specifically whether your home is exposed after the death of the surviving spouse. Find out if a ladybird deed, a life estate, or a trust structure could help preserve the property for your heirs. Third, find out your state's specific rules on IRA and retirement account creditor protection for inherited accounts. This is not a general Google search question. This requires a state-specific legal opinion. Some states offer full protection. Some offer none. You need to know which side of that line you are on. Fourth, if you have adult children who are in business, going through a divorce, or carrying significant personal debt, talk to an attorney about whether naming them directly as beneficiaries is still the right move, or whether a protective trust structure makes more sense. Fifth, if you have a surviving spouse who is younger or in poorer health, review your entire plan through the lens of what happens to them after you die, not just the accounts, the income, the Social Security, the Medicare costs, the home, the estate recovery risk, every layer. Here is the final warning. The Supreme Court did not send you a letter. Your state Medicaid office did not call. Your 401k administrator did not update you. The rules changed quietly, in legal language, in courtrooms most people never follow, through decisions most financial advisors never explained. But the consequences are not quiet. They show up when it's too late. They show up in a probate filing, in a Medicaid recovery notice, in a bankruptcy proceeding that wipes out a lifetime of work. You built what you built because you were careful, because you planned, because you thought about tomorrow when it was easy to only think about today. Don't let a legal technicality undo what a lifetime of discipline created. Review your plan, update your documents, protect your spouse, your children, and the assets you earned. If this video reached you in time, save it. Send it to someone you love who has an IRA, a paid-off home, or a retirement account they think is fully protected. And subscribe, because the rules keep changing and someone needs to keep warning you when they do.